Introduction to Law. Sources of law continued. Judicial precedents. Stobb is of the opinion that precedent refers to the practice of law and the practical application of something cannot be regarded as a source of the same thing. Keaton rejects the aforesaid view of Stobb and holds that a judicial precedent is a valid source of law. He defines judicial precedent as a judicial decision with some amount of authority attached to it. This authority is because of two reasons. Firstly, the judges occupy a high status politically as well as socially. Secondly, the nature and the importance of the issues that they decide upon attach some amount of authority to their decisions. Blackstone is of the opinion that former judicial decisions must be binding in the future when similar points come up for judicial deliberation to keep the scales of justice even and steady. Stare decisis. Concept of stare decisis. It is a doctrine or policy of following rules or principles laid down in previous judicial decisions, unless they contravene the ordinary principles of justice. Theorists on custom. Salmond defines custom as an embodiment of principles of justice which have appealed to the national conscience. Keaton defines customs as rules of human actions which have been established by continuous usage and have the force of law and are applied by the courts. According to Carter, the simplest definition of custom is that it is the uniformity of conduct of all persons under like circumstances. Austin, in his disregard for custom as a source of law, defines them as rules of conduct which are simply observed by the governed, in a non-legal sense. Two kinds of custom. Customs are of following kinds. Legal custom. Legal customs are those customs which have the full force of law, regardless of the party's acceptance of the legal custom. It is binding upon them. These are of two types: general custom and local custom. General customs are applicable throughout the nation, whereas local customs are specific to a particular locality. Conventional custom. A conventional custom is binding upon the parties to the dispute only if they agree to it. These are established practices which are agreed to by the parties in an agreement or contract between them. Requirements for a valid custom. A custom must fulfill the following requirements in order to be recognized as a valid custom in the eyes of law. 1. It must be immemorial. That is, it must be in existence since a long period of time. 2. It must be reasonable. 3. It must have been continuously observed. 4. It must be certain and definite. 5. Its observance must be compulsory. 6. It must be general or universal. 7. It must not be opposed to public policy or principles of morality. 8. It must not be in conflict with any statutory law in the country. Professional opinions and juristic writings. Professional opinions and juristic writings mainly comprises of obiter dicta of judges, writings of legal professional and other thinkers and scholars, been disregarded by some as sources of law. Bodenheimer divides legal sources into two categories: formal and non-formal. Formal sources are sources available in an articulated textual formulation embodied in an authoritative legal document. Examples include constitutions, statutes, judicial precedents, etc. Non-formal sources are legally significant materials not formalized in a legal document, e.g. standards of justice, moral convictions, customary law, etc.